But I'm sure that Mr. Singh will explain then as such difference to the Indian law in due course. When I come back to the two cases I learned about, and there was something said from Mr. Goyal about early certainty. You need to know what is patented and what is not patented. For that, you need early decision of the relevant authorities, and we learned today that the Indian Patent Office, also the EPO, is making a huge effort to come as early as possible to a decision. Fast and early is not the only issue of it. There is also an issue of quality. And with quality I mean correctness and global validity of such a decision. We don't, and when we take the first decision you can have in a patent system, it's a search report. The first search report you get about an invention you think you have made. There, before you go to continue heavy investment in your business, it's advisable to have a search report in hand which has a kind of a global validation, that there are not documents missed out simply because they are not in the collection of the database of an authority who is searching for. With this respect, I can refer to the database of the European Patent Office, which is the world's largest patent collection which exists in the world for the time being, and to the fact that we have not only have a patent database collection at hand, we also feed in a lot of what we call non-patent literature, being scientific literature, being publications in journal, being general knowledge retrieved via handbooks, but, and it's important for this ICT area as well, we enhance it with documentations we get from standardization gremia, because we know there are things discussed and debated on a technical level which are public, but not so easy retrievable, because no one has an interest to publish them just like that in the internet. And there we have made quite some agreements to have those documentation incorporated in our search tools, in our search reports, which will enhance the early certainty. The same thing is the expansion to the readability and retrievability of prior art which exists in Asia. With excellent translation tools and sophisticated classification systems, we now have in some areas up to 30–35% of Asian documents cited in our search report, which I think is somehow amazing for a European organization which primarily looks, of course, at European patent documents, but we look very much abroad and try to be complete. This completement has its costs and its price, that's very clear. But if you think, when I take your example, that you invest some 450,000 rupees or more?
4,500 crores.
Crores. That
4,500 million.
Huh? How much?
4,500 million.
Yeah.
Yeah. So a huge amount, a real huge amount of money in the technology. Then we have to say a proper patent search on whatever it might cost, and a proper opinion given from a competent authority, and they refer to the EPO as a PCT authority, might be a negligible amount of money. In particular, if it turns out that all this investment is already prior art, you can do it, but at the end of the day, you might have to pay royalties to someone else who has filed it first. And there are some of these few errors or mishaps we find in a patent office from time to time from applicants, that great things are invented, however, they have already been described somewhere by someone, somewhere in the world. And this is the point of prior art. It does not need that it exists in praxis it's just enough if it has been published and described in sufficient way. So we strongly advise for a good search. By the way, the European Patent Office is also one of the major contributors to give its prior art away for free by means of ESPASnet, and if you would like to have a better surface, the Global Patent Index for relative low fee, you can have access to it and can have a first search on your own, which costs you no fee of charge. It's just the internet connection to the server of the EPO. Yeah, more or less that's what I wanted to add at this stage of the session.
Mr. Anand, can I add
Great.
something? Why I am back? For the first time in my life, somebody responded to some of the questions I raised, so thanks to Weber. And I think it is because you are ICT and EPO that you have answered the things. My problem is I go for search. First of all, proper, competent. And there are thousands of consult attorneys in the world. Who is proper, competent? Secondly, suppose I appoint EPO as a consultant attorney and you give a search report, would you be held liable if something is missed out? No. No. Absolutely no. That is the problem we have. Another point, as per studies, you all know, you are experts, there are 80 million worldwide patents, 2 million SEPs. I want to make a cell phone using a 3G chip of XYZ company. How are you going to find out around 80 million patents applicable or not? Thank you.
The final word.
Thank you, Mr. Chair, and good afternoon once again to all of you. Gentlemen, to start with, because I am the first person to speak on behalf of Indian Patent Office, though my representative from our ministry, parent ministry, our director, Sri Satpute, has already spoken. So, I thank the Controller General who has provided me this opportunity to interact with you. Our relationship with EPO goes back to a decade when Mr. then President, Mr. Pompidou, accompanied by our friend Mr. Nicholas, visited 2007. And many people in audience always you refer that approaches of Indian Patent Office, particularly where the CRI concerns, is more or less we are towards, I mean, it is EPO approach, or you correlate Indian approaches to EPO, nearer to EPO, find nearer to EPO, not that of US. But I will give you a different perspective altogether. In 2002, our law mentioned explicit exclusion for computer-related invention. But prior to it, the definition of invention itself was different. And you remember what was the definition, many of you, because all are from fraternity. And you don't have to go back here and there. You can refer Article 101 of USPTO today. More or less, the definition was same. US, after WTO came into being also, the definition of invention in USPTO has not changed till date. It is same manner of manufacturing, and in that article manufacture product, etc., etc., Article 101 is clear. We changed it. Ours was novel and useful method, manner or process for manufacturing or the manufactured product. In that, the software was not fitting in, and hence this was examined even then prior to explicit exclusions. Came the explicit exclusion, and we are talking about these three guidelines. 13 onwards we started this exercise, and 17 we have closed it for time being. It is a law is evolving process, you know. 2005 we came out for the first time with examination guidelines on computer related invention, because we included a particular section 3K in the statute. So that was the time when Indian examiners and Indian fraternity as a whole required some clarification onto it, and a guideline came. After that, there was enough clarity, and again in 2016 when there was the requirement was felt, in 2013 we have given the first draft, and finally that was finalized in 2015. Our director has given you the view that how these changes took place from 15 to 16 and to 17. 3 years, 3 guidelines. We don't see major shift in the approaches. And thank you, Mr. Teresia, to acknowledge that many countries must have taken many years to come to this conclusion, which we could take as spontaneous. So this means Indian patent regime as such is fast growing, fast moving. Answering one small question of the chair today, that Indian filing. Yes, we understand that we should talk globally and compare ourselves with the neighboring China. Yes, we are pretty low. But if you compare ourselves with 1995, 3,000 application, and today, 20 years down the line, we are having 48,000, 1,600% increase. So, you can't overnight jump, and there are n number of factors. There is being created by the ministry, by the executing body, that is Office of CGPTM, but still, if you have full-time researcher of the quantum volume of 100 full-time researcher per million people as against China, which has 1100. So have we thought on that angle any time? That if China has 1100 researchers full-time per million population and India has just 100. So is only that patent, how patent will come? Patent will come from those researches. Still, patting at the back, we can always say that there is a 1,600% increase, but we understand that there is a big gap between us and the countries which are promoting patents and awareness generation. We again talk in the closed room, have seminars, we are not able to reach out to the people, to the grassroots inventors, and there is opportunity. Now of course we have opened, we are going to schools. Ever since the CPAM has come into being, there are n number of programs being conducted, but in spite of everything, we need propagation of the phenomenon that the IPR exists. What a best example that some agency is investing 450 crores of rupees having 2 patents on its kitty. So this means there is lack of awareness on every corner. So that has to be generated. To CRI, today, of course, as sir has pointed out, that many people are familiar faces which interacted with all of us while we were formulating the guidelines, and we congratulate you all, in fact, that you came to a conclusion that look, Indian patent guidelines on to computer related invention must take this shape. So I congratulate you all for taking this view and making it possible for us to give a guideline which is acceptable to each and every stakeholder across the idea spectrum. Just comparing these 2 guidelines in EPO and India. By name itself you can just read. EPO guideline is computer implemented invention. Our guideline is for computer related invention. Which one is wider? Which one is wider? You can always say that once an invention is being implemented by a computer, that hardware is there already. Nobody can deny a fact that if a computer implemented invention, I am discussing an invention where the computer is already there. But here in India, we are discussing an invention where it is relating to computer, may or may not be. Computer may be there, may not be there. So our lawmakers, our thinkers, and our think tank is far more open towards the future technologies which are coming. We have been talking about artificial intelligence, and rightly put, we have a technical person in Mr. Viswanathan session, we had a lawyer, and I am blended with both. I'm a engineer lawyer. So I'll give both the perspective in that sense that though the technology and law has to take pace with each other, but always there is a mind behind machine which works. Artificial intelligence were there since 1956. But the more you now think, whatever we never know, that was artificial intelligence. Now, Diamond Deer case I will just add here in US. You used to take a temperature, a manual temperature, particular at different point of times, one used to take the temperature on a rubber curing. It was made through some software. Was it not artificial intelligence then? That you never know. You don't know at what time the temperature is to be taken. The machine is taking the temperature at that particular point and deriving various other parameters for rubber curing. No sooner, OCR for matter. OCR was rated once upon a time artificial intelligence, but today it is no more artificial intelligence. Is it not? So things which we do not know, we safely put in somewhere which human mind doesn't perceive today. Coming to conclusion that it is always the mind behind machine which will work. If certain patent laws in particular jurisdiction of world are holding good, even after 20 years of implementation of WTO, with all the modern technology taking shape, we should not think too much on law, we should think on implementation. How the law is being interpreted. The lawyers will be the best person to judge that on the same law, both the adversaries fight and one of them wins the case. So, coming to summing up, the Indian Patent Office, after devising the guidelines, are fully equipped. Somebody, again, to clear the perception which many people have that these guidelines in 3 years took 3 different shapes and the patent filing gone down in ICT. It was a myth. If I was permitted to show you the slides, I would have shown that. It's a gradual increase in the patent filing in ICT domain, and today we have registered in fact 35% to 40% of the whole filing in ICT area itself. So this is just a myth that these guidelines has given any effect. In fact, people have been liberal in filing, though we expect very many applications to come in. We are fully equipped. One, speed also was mentioned by chair, and I'll answer to this is, till yesterday in the sense till 2016, we have examined only 16,000 applications in a year. Just example. Today, we are in month of November, we have already crossed 30,000. So what could be its speed? It's more than double in 4 months to go. This means the number of examiners, thank God you have appeared in Nikodenko case. Somewhere or other Nikodenko has given some leverage in augmenting the human resource in the Indian Patent Office, and that has yielded result. A patent examiner who was examining application being relating to ICT sector filed in 2009 till 2016 is examining applications filed in 2014. So this means we have already reduced. And morning you have listened from the Lions Boys, Joint Secretary was here, and he was telling that come 2018, our target is to bring the pendency to less than 18 months. Whether or not we'll be achieving, but that is we have put a challenge in front of us that March 18, we bring down the pendency to 18 months. This is far beyond the imagination of any foreign jurisdiction. Again, our filing system, what better facilitation that we can provide to the filers? 24/7 hour basis filing. I do not think in any country in the world provides 24/7 hours basis patent filing. They only provide in their office hours. 9 to 5 they work, you file patent application 9 to 5, they will receive, minus that, goodbye. India is the only country which gives you leverage to accept the application, to file the application 24/7 hour basis, work for 6 days, sit down at your desktop sweetly, with a cup of coffee on Sunday, file patent application. We receive it, give you the date. So, such facilitation from Government of India, from Office of CBDTM, still if something is suggested, we'll certainly take. And again, coming back to my friend, Mr. Goyal, I will also supplement with the same idea of my friend Mr. Weber, that we are again executing body, we administer law. Whatever law is there today, any filer, patent filer who comes to patent office never discloses first that whether he has got ACP or not. It is only after the grant of the patent that he finds himself that he is part of some standard somewhere, or he makes himself a part of some standard. So, always we can have some databases created, but that view has to be taken collectively. Government of India has circulated a paper onto ACP, and a view has to be taken. But we sitting in patent office, either in IPO or in EPO, will not be able to be in a position to tell you that how many patents are coming in particular standard, because it is only after the patent is granted, then that whether its utility is there in particular standard or not, that is decided by the standard setting authorities. Thank you very much.
Thank you very much. Thank you very much, Mr. Singh. It's very heartening to see such passion as Mr. Singh has, and the Government of India has obviously done very well in having people like him there at the Patent Office. I think we've had most of the issues that were brought up dealt with. Why don't I give an opportunity to the panelists to raise any questions before I throw it open to the audience. We have about 10 minutes. So maybe we could take about 5-6 questions. So anybody in the audience, in the panel, would like to ask a question? No? All right. So anybody in the audience? Yes, ma'am.
So you mentioned that judiciary has set up a timeline under a Commercial Codes Act. Sorry, government has set up a timeline under Commercial Codes Act where it has to, the decision has to range from 1 year to 1.5. I just wanted to know, being in the legal profession, I just want to know whether the timeline is actually being adhered to.
Unfortunately, it has become a roller coaster. We are all, even when you want high speed, you don't want it so high that your witness is unable to come to India because of Christmas, but the judge says no. In the summer months, I could not join my family for a holiday because the Supreme Court in the Merck versus Glenmark case ordered a trial to continue in the month of June during summer. In the Pfizer case relating to sunitinib, an anti-cancer drug, the court on, I think, in 3 months after the suit was filed, the defense was not up to the standard. The court not only struck out the defense under the summary procedure of Order 13 capital A of the Commercial Codes Act, but also granted 20 lakhs of rupees as damages. The person preferred an appeal to the division bench, then the Supreme Court, and both the appeals were dismissed and the order. So now what has been announced by Justice Valmiki Mehta just 3 days ago in court, he told me to tell all the IP practitioners that from now on, at the time of framing of issues, settlement of issues, they should keep an application ready for summary procedures for dismissal of the suit or decreeing of the suit, depending on which side you're on. At the stage of framing of issues, the court will decide that. And the whole lawsuit from beginning to end is divided into 8 components, 8 parts. Let's take one, filing of the written statement by the defendant, maximum of 120 days. If it is not filed in 120 days, the right to file the written statement is closed and it moves on to the next stage. So it is, like I said, sometimes speed is good, but overspeed sometimes starts to hurt even the person who desires speed. It has become really fast, but fantastic, very refreshing. Not only that, the judges have started to feel like commercial courts. So their entire attitude has changed towards fast speed. And so finding that kind of refreshing change and finding this kind of passion at the patent office, I'm sure every day will bring change. And that's what we are looking at. We want change to come every day of our lives. That's the only way we'll be able to address this fantastic phenomena of artificial intelligence and Industry 4.0. Right. Yes, sir.
My question relates to CRI. We had two words used here, computer related inventions and computer implemented inventions. Now the way I see it, it might be simplistic, but let's look at a block. You have a computer and you have a software. Software runs on the computer. So this means the software runs on any computer. It doesn't matter what processor, what technology, it doesn't matter. So what is the difference between the two? It is a thought that is creating the novelty, not the outcome. So whether it is used as a copyright, let's say use Microsoft Word for example, it's because I'm writing my thought, I can format it, therefore it's software, it's copyright. But I use a similar tool and do something like we mentioned, for example, rubber, or I do something like measuring temperature, or I create data points. What's the difference? So basically I think, I might be overreaching myself, but we need to split the invention into two parts, computer and software. Now specifically, for example, patents on noise or patent on data compression. You are able to compress data because the data follows a law. I'm saying I sent 400 points, I'm good with 200 points on the other end. So question is, what is the distortion? And therefore it follows a mathematical law or mathematical rule. So if you are essentially these inventions only become mathematical laws implemented on a processor. So the point I'm going to highlight is, our patent law is very clear. Mathematical equations are not patentable. They further supplemented with by 3K, saying that computer, software, etc. We just read out the whole detail. So the patent law comes down heavily on 2 points: software, mathematical invention, and thought. So I think my recommendation and my request is that we need to look at CRI guidelines again, because in 3 years, 3 different interpretations of the guidelines have happened. It still needs to be tested at the court of law. So the point is, what is the CRI guidelines doing? These CRI guidelines are telling the SHO, do not file an FIR. Can you tell an SHO, do not file an FIR? I'm open to court. So the mandate or the responsibility, who files an appeal, shifts because of these CRI guidelines. If I'm the patent holder, you don't allow me, I appeal. If I am the sufferer, then again I appeal. But who appeals is what shifts. So that might be a decisive factor in the condition of, not so well developed technology and our economic environment.
Thank you. As we've heard, we have 2 energetic members of patent offices here who've become pretty energetic as that question expanded. And I would pass the floor to Mr. BP Singh first of all to answer, and then afterwards to Mr. Weber.
Okay. Thank you for your very nice question. One thing is common. Once you see all 3 guidelines and if you scrutinize them properly, you don't find much change other than 1 or 2 words here and there. Though even with those words, novel hardware also, the 16 guidelines were having many things which are common to today's 17 guidelines. So I see that more or less we have not shifted the stand, so to say. Rather we have tried to put in a different way